We will begin in 5, 4, 3, 2.
Welcome, everyone. I'm David Leibowitz with Lake Law. I'm very pleased to be introducing and moderating today's panel, Professor Bruce Markell from Northwestern University and Professor Bob Lawless from University of Illinois, Urbana-Champaign. Before we get started, let me share with you some important details and notes. First, if you should need any assistance during this virtual event, please email to support@abiworld.org. That's support@abiworld.org. If you need CLE, you have to be sure to answer the poll questions that appear throughout the session. Don't talk about the poll during the chat, just answer the questions and go on with life. At the end of the session, there'll be a session evaluation, and we will ask you to take a moment and complete the session evaluation before you leave. The ABA CLE department will reach out to you with instructions on how to confirm your CLE credits. Additional CLE information can be found at our website, cpex22.com, cpex22.com. Third point, CPE is not available for the conference. Fourth point, during any of our panels, if you have any questions for the panelists, please put them into the chat function. You could put them in the Q&A, but we have a better chance of seeing them if you put them into chat. If there's time during this session, the panelists will answer your questions throughout the session or at the end if possible. Just so you know, the question and answer and chat function will be available to those that are watching on Cpex. We know that there are others watching on other channels, but only those of you in the Cpex channel will have a chance to ask questions now. So now to the topic at hand, if I were king. We have some people that know just what they would do if they would have the choice, but they're going to tell us. And today, to start the topic, I'm going to ask us, our panelists to talk to us about current events, specifically the Department of Justice's press release about how they would like people in the Department of Education and the Department of Justice to handle student loans. Take it away, gentlemen.
Yeah, so before we get to the Department of Justice did yesterday, so let's talk a little bit maybe about the Biden, where we're at with the Biden administration's actions, because I think, one question would be, what, and I think this is going to be being asked more and more, why do we need bankruptcy and undue hardship if the student loan problem is going to be taken care of outside of bankruptcy court? I think, as a lot of people know, the Biden administration announced that they would forgive $10,000 of student loan debt, $20,000 if you have a Pell Grant, and most people who have a student loan also have a Pell Grant. So $20,000 to student loan forgiveness if you're under $125,000 of income as a single person and $250,000 as a married person. So that's going to cover about half of everyone with a student loan. They're just going to have their student loans wiped out. As I think a lot of people probably know, that executive action, which I should say is formally an announcement by the Secretary of Education to waive certain rules under the Higher Education Act. That executive action has been stayed by a district court in Texas and now the Eighth Circuit. Who knows where this is going? I don't know if Bruce has different views on this, but reading the tea leaves, I don't think that's going to end in a favorable outcome for the administration.
I think that's right. I mean, I believe yesterday the Biden administration, Department of Justice, has requested a stay of the Eighth Circuit decision. But at the same time, I don't have great hopes for that. I mean, there have been two challenges previous to this that let the student loan, that left intact, if you will, the student loan forgiveness, for which stay requests were made. They were both denied, I believe, by Justice Barrett. And so, I mean, in terms of the interim relief, that is to say, to get all the courts to back out until the Supreme Court ultimately decides it, my guess is it's going to be frozen for a while. And my guess is if it gets to the Supreme Court's going to have to figure out, basically this, as Bob kind of hinted at, turns on whether or not the administration can cancel or waive the debt. And that argument turns on whether or not we're in a state of emergency because of COVID. I believe, correct me if I'm wrong on that, Bob.
I think the word is, so I think it's waive or modify
Waiver
And
modified,
it's,
thank
the
you.
phrase is national emergency. I don't think there's much question. We're in a national emergency. There was a
Right,
presidential declaration of national emergency by President Trump, and that's the operative
right.
thing. It's a term of art.
It is a term of art, and what we're seeing though is, I mean, there's not really a connection, or at least there's not a direct connection between COVID and the student loan. Most of the student loan debt was piled up before COVID. And I could see, I don't agree, but I could see someone saying, well, yeah, there is this national emergency, but it's unrelated to what the waiver was. That argument may be the one that's going to be pressed. There may be others. I think that's all unfortunate, because I think actually, it's, if you go to plain meaning, which is what the court seems to like or have liked under Scalia and currently, I think your argument, Bob, is absolutely correct. Just read it. It's waiver modified. It's national emergency. What more do you need to know?
Yeah. And I should say also, I'm not speaking here what I think should happen. I'm making predictions about what I think will happen. And we don't want to spend too much time on this, but it was something that people have focused on, Bruce, so it's waiver modified. I think there's a substantial arguments both sides, right? Whether Congress intended the Secretary of Education to have an across the board, you can just wipe out loans without the relief being more narrowly tailored to the circumstance, which I think is similar to something you're saying. But also, if you read carefully what the Secretary of Education said, is that he's exercising power under Section 1870 of the Higher Education Act, at least Title 20 of the U.S. Code. And that section does not have a general waiver provision in it. It has discharge or waiver provisions, for example, for students who become disabled, for students who are unable to complete their degree program, et cetera. I think there's a strong textualist argument that under the administration's own reasoning, their waiver can only apply to a limited set of loans.
Yeah, and the unfortunate thing about this is there are a number of people whose loans are at or under the $10,000–$20,000 range.
Yeah.
They are going to be in a world of confusion as to what they have to do when the payments start up again.
That's exactly right. And we're kind of pushing one side of this. And again, I don't think normatively both of us don't think the cases should turn out this way. But also, we haven't mentioned the standing issue. And again, I don't want to spend too much time in a bankruptcy CLE talking about constitutional issues, right? But
as I say, con law is aptly named.
And
Well, why not? The bankruptcy code actually was derived from Article 1, Section 8, Clause 4 of the Constitution. So go for it. Be constitutional.
Well, all law, right, is derived from the Constitution. But I just think I'm guessing many of our fellow compatriots here in the bankruptcy world share our views here. But just know on the standing issue, the administration actually has some strong arguments there. So I think if the administration is going to win, it's going to be on standing arguments, not on the statute.
Right. I mean, this is a key case in which you would hope people would separate politics from the legal issues.
Yes, that happens.
Lots of luck there. Lots
Occasionally.
of luck there.
Well,
So I think
I said hope.
I suggested we start there just because.
Right, if that happens, then none of this matters for a lot of people. But there are a lot of people who have more than 10,000/20,000 in loans. And so I guess that means we move on to non-dischargeability, right, Bob?
Yeah, that's what I was trying to say. Yeah. So first, even if it's upheld, there are going to be people who aren't going to meet it, or are going to have loans above the threshold. And then, as you point out, there's this limbo, which takes us to yesterday's action from the Department of Justice / Department of Education. We were told to talk about recent developments, so you can't get any more recent than yesterday.
So let me ask
In
you
under
this
24 hours.
Yeah.
Let me ask you this question. I mean, does the guidance from the Department of Justice change Bruner, or does it only provide for an interpretation of Bruner along with the totality of the circumstances? So, is this a legal document, or is this an interpretive document, or a little bit of both? What do you think?
Bruce? happy to.
Yeah, I was gonna, yeah. When you want time to think about it, you send it over
No,
to me.
yeah,
I think it's a little bit of both, although, I mean, what you have is basically the guarantor of most of these loans saying these are the situations under which, we won't object to, our loan, our guarantee being modified, if you will. The Bruner test, as you know, has been under attack since it's been certainly over the last 10 years. The Bruner test was under a different law even than the law is currently. One of the things I think that happens here is, again, we're less than 24 hours into this. I read what the DOJ put out. It's extremely detailed in what it does. And in some respects, it tells us a method for determining undue hardship, which I can't believe is that much different than what people were doing before. They were comparing Schedules I and Schedule J. And that's more or less what this does. I think where the real help and maybe the real variance from Bruner and Bob, tell me if I'm wrong on this, is setting out some guidelines for when, if someone can't pay now, when they can't pay in the future. Setting forth some provisions like age, like failure to complete the degree requested, certain disabilities. They're kind of outlining those as legitimate grounds for saying that can't pay it now, can't pay it in the future. And I think, there's not much in there, but there's something in there with respect to good faith, which I think got interpreted in many different ways. Like you don't go knocking on the door for debt relief outside of bankruptcy. You don't have good faith. I think that may be modified a little bit in terms of what they're asking people to do. But I don't know, Bob, what are your thoughts?
yeah. Like you say, this is less than 24 hours old, and so everyone gets to see us we haven't even talked among ourselves, like what we think about this. So everybody gets to see us in real time, try to figure this out, I guess. So first, I think everyone has to appreciate this is a guidance memorandum from the Department of Justice to its U.S. attorneys. The Department of Education is a party to it, in that the Department of Education has agreed to provide certain data to Department of Justice attorneys, I think in an effort to try to make it easier on the borrower. So loan information, loan history, et cetera, is supposed to be provided by the Department of Education directly to the U.S. attorney upon request, upon following the procedure that's in this document. David, you asked, is it an interpretive document, is a legal one? Yeah, it's a little bit of both. I'm sure there are no private rights that accrue under this document. Again, it's just, internal guidance within the Department of Justice. So, if you want to claim the Department of Justice isn't following its own memorandum, write a letter to the Attorney General, I think is your remedy there, right? I'm sure that letter will get all the attention it deserves.
I'm not sure. I think actually if it were the case, and that's an intentional use of the subjunctive mood, if it were the case that the Department of Justice was varying from this, I think a bankruptcy judge would be very interested to know why. And I think the credibility, if you can make an argument that they're trying to move beyond what the official position is, actually would augur in favor of the debtor. But that's a litigation tactic to make the other side look bad. I don't know, but I doubt that they would be doing that unless there is a sincere good faith dispute over what part of the memorandum means.
Yeah, I think you just wanted to work the word augur into the conversation, but
don't get all screwed up about it. It's okay.
Ooh.
Ouch. Anyway, but I think so one of the documents, this gets back to your question, whether it's interpretive or not, David, is there, I think there's enough wiggle room in the document that I think a competent U.S. attorney could always argue that they were following the terms of the document for reasons, for other factors. So I don't want to be too flip that, I think if I agree with you, if it got just blatantly ignored, I think a bankruptcy court would be concerned about that. And maybe it'd be useful to talk a little bit about, kind of break the document down. So so first I'll just be direct on first read. It appears there's less than meets the eye, but as you study it more, I think there is a lot there, and I think it's a positive development if you represent consumer debtors. I think it is going to make a lot of difference, but you have to dig into the document to see that.
I mean, let me just also do a caution before we do this. I mean, we all know that if you're going to contest dischargeability, it's an adversary proceeding.
Yeah.
We also know that most attorneys will exclude adversary proceedings from their general retainer agreement. I think this is going to present problems because, I think the poll just moved up over us. At least it's on me, but answer the poll so you get your CLE credit. And I guess my point is, if in fact some debtor is paying an attorney separately to do this, there's going to be a lot of work in filling out the paperwork that's necessary here. It might be something done by a paralegal, but it's going to be a lot of work. And I pity the poor pro se debtor who probably doesn't even know they have to file an adversary proceeding. But then when they do, they're going to be hit with, as we'll talk about, this attestation that the DOJ wants is quite complex. I mean, we'll get into it, but it's going to require a fair amount of work. So, I mean, I just want to throw out there that there's, this looks good, but the question is always like, who's going to do the work? And that's going to be problematic.
A great opportunity for pro bono attorneys, right?
That's an interesting use of the word opportunity, but yeah, I agree.
Maybe for legal clinics and universities.
You're getting a little bit close to home there, but okay.
You take what you can
Yeah,
get, right?
I agree with that 100%. I think that's one of the issues. There's always also the issue of not letting perfect be the enemy of the good. I think there is a lot in now, and they do try to address cost, but kind of the paradigm use of this memo, I think, is going to be well represented debtors who've hired a competent consumer bankruptcy lawyer who's able to navigate the thing. And if you're, I presume most everyone listening as a consumer bankruptcy practitioner, you really need to look at this document and read it, and because I think it is an important.
There are 3 documents, right? I mean, just to be clear, right?
Well, yeah. Well, there's 2 appendices. Yeah.
Right. Well, 3 documents, 1 document, 2 appendices. Yeah, I guess my appendix is not. It's in my body, so it's not a document. But I mean, we haven't talked about it yet, but one of the appendices is this attestation I've referred to, which basically requires the debtors to refill out a lot of information they've already given in Schedules I and J. And I, for one, am just kind of confused as to why they just didn't say, just attach your I and J or incorporate them by reference.
No, so I think, so first of all, everyone who's watching should know that Bruce and I pick at each other like this, even when we're in private. But I think you're missing something, right? So it's not Schedule I and J. So the memo does do the Bruner test more or less. It's got some changes. The first prong of Bruner, instead of the minimal standard of living language, although that language is later in the memo.
Yeah.
The first prong is basically ability to repay, and that's what the attestation form primarily goes to. But you use a lot of the IRS guidelines that are used to determine current monthly income. So I don't think it's just simple. It is different than just laying Schedule I and J next to each other. Of course, if you have one thought that just occurred to me, if you have a below median income debtor, you haven't gone through the IRS exercise of expenses. I think one thing, often the IRS expense, not always, but often the IRS expenses are more generous than what the debtor's actually spending.
Right. Even in their, I think even in their, the 3rd document, the 2nd appendix is an example, right? And it does have a part of that example, as I read it, was at least one line item that was more favorable to the debtor. So.
And one of the things about the memo, and this is where I think it is making a lot of change once you kind of dig down into the details. If expenses are more than income, and remember, you're using your means test expenses. If expenses are more than income, then the first prong is presumed to be, not even presumed, it just says the first prong is met.
It's satisfied.
Yeah. And I think that's a big deal. So
No,
I
no,
agree.
I agree. That's a big deal. I'm thinking in terms of the practicalities of this is why you would want fillable forms, to find out. I mean, because again, I fear the poor debtor or the poor paralegal who has to make sure that they don't screw up when they're transferring numbers from I&J to this attestation. Or
Yeah.
maybe it's another form that has to be, the DOJ suggests it ought to be filed at the beginning of the case, even before they do, before they even commence an adversary proceeding. But I mean, there's at least 10 or 20 different blanks to fill in of numbers from I&J. And my experience was not like do pro se's have trouble doing that, but attorneys do too.
Yeah. Yeah. No, I think that, right. We should, I don't know. It's the attestation form is 15 pages.
Right.
And there are not only places to fill in things, numbers, but there's also text
Narrative.
entries that about other circumstances to identify.
Right.
So this is how you do the first prong. And again, it's not Bruner, but it's, I guess, maybe quasi Bruner is kind of the memos.
It's basically it's if Bruner married the means test and they had a child.
Okay, I take no responsibility for that last comment. But yeah, so that's the first, but then the second prong, right? That the circumstances are likely to persist.
Right.
And you referenced this. I think that's a real game changer there. So you mentioned, right, there's now some specific circumstances in the language of the memo is that it's a presumption that if you you have these circumstances that you are presumed that your circumstances are going to be likely to persist. It's over 65 and more bankruptcy debtors are over the age of 65, at least now about 1 in 6, according to our research data that we collect over 65. If you have a disability, if you've been unemployed for 5 of the last 10 years, if did not obtain a degree with the loan that you had, or you've been in payment status for 10 years. So the way I read that, I was somewhat surprised to see that, but the way I read that is after 10 years, you're presumed to have a persistent inability to repay. Right. Now, there is those are not the only factors. Those are all listed in the memo as things that establish a presumption. So we're just mentioning, there's places for text entry. So there's a place where you could list other circumstances that show a persistent inability to repay, other than those listed. But I think those cases are going to cover a lot of the undue hardship cases that arise in the world.
Right. May I, and again, just for those of you who don't have a memo, we'll try and put a link in the chat to it.
So it should be if the materials got distributed, the memos attached.
It's somewhere in there. It's also on the DOJ website.
Yeah.
Obviously, but as I kind of indicated at the beginning, I think these are kind of some of the major changes from Bruner. Some cases have taken that into account, but now in essence, this is nationalizing those and actually putting them in the form of checkboxes. I mean, it's not like someone has to write out, I've been unemployed for the last 5 or 10 years. It's just a box you check to say that you've had that status, and presumably, you're telling the truth when you do that.
So, gentlemen, we've spent about half of our session going through this, which I think is vital, and I'm glad we did it. I think we could turn to some of the other items that we had considered. Would you like to talk about the bankruptcy legislation that Nadler and Warren introduced, and what might come of that now and in the future? I mean, I know that it's dead in this Congress and probably dead in the next one, but ideas have a way of persisting. What ideas in that proposed statute do you think have merit and may have legs?
So a few things. So first, it's been reintroduced. It was reintroduced in October, or September. It was reintroduced in September. There was a committee hearing scheduled for the last week of September. That was actually, yours truly was supposed to be a witness at that hearing. It got canceled at the last minute because it was scheduled on the last day of the congressional session before the election recess. There was legislative business, so there may be another hearing on this bill. So kind of stay tuned, watch. I'm sure the ABI will keep its members informed if another hearing gets scheduled on that. I've heard kind of noise that there might be still a hearing on this. So there's still interest in this reform. I should also disclose that I was part of the drafting team. So, take everything I say with that in mind. So the reintroduction still continues the basic concept of a one chapter consumer bankruptcy system, a chapter 10, if you will. Yeah, I'll tell you, as part of the drafting team, it's just the average of 7 and 13. Had to pick a number. But there's also
organizations into the act with chapter X. People are going to be confused.
Yes, yeah, it's Roman numeral, or not Roman numeral X. It's chapter 10. It allows people to file bankruptcy for you can file just a plan to take care of a home mortgage without involving your other debts or a car loan. I know there's been a lot of trepidation, I guess, in the consumer bankruptcy community about some of the changes. I think there's a lot of tools there for people who represent consumer debtors. Secured loans can be reamortized, debts are written down to the value of collateral. The consumer process becomes a lot like the business process. There's about, my estimate would be about somewhere around 90% of debtors would have a very quick and hopefully therefore very cheap in and out of the bankruptcy court. You get your discharge right at the front of the case. There's no waiting for the planned payments. For the 10% that would have some sort of payment obligation, and the buzzword the statute uses is minimum payment obligation. For the 10% that would have that, you get your discharge. Now, the other side of that is there has to be some collection of that obligation if you don't do that, and that would be assigned to the trustee. The trustees would be collecting payment obligations if the debtor does not pay through the plan. So that's, I guess, in a very, very broad scope, what the legislation does. The reintroduction changed a few things. There's a little bit broader language to excuse non-payment of the minimum payment obligation for kind of bespoke circumstances. There's a security interest to secure if to the extent the minimum payment obligation arises from non-exempt assets. There's a security interest that arises on those non-exempt assets that the debtor chooses to retain. As in current law, if the debtor doesn't want to retain non-exempt assets, they can turn them over to the trustee. And but the reintroduction changed a little bit about how that security interest would operate. Another important feature of the legislation is that it would allow for payment of attorney's fees post-petition through a post-petition agreement. And the legislation changed, the reintroduction changed that, so the agreement would get enforced through the bankruptcy court on the attorney's fee side. So, I think there's a lot actually in the legislation for consumer practitioners to use. I kind of was part of the drafting team. I should also say, right, it's Senator Warren's bill. Just because I was part of the drafting team doesn't mean that maybe people remember this famous quote, not every word in the bill I necessarily agree with. I think the quote was in the other direction.
Yeah, it was in the other direction.
Yeah, it was. But so that's just a little bit of overview on the Consumer Bankruptcy Reform Act.
Professor Markell, it seems to me, just looking at this from someone that deals with the existing bankruptcy system a lot, that these are fairly radical changes to the overall scheme of things. What do you think the likelihood of all of it or some of it coming to pass? What features of it do you think are particularly likely to have some legs, and what features do you think are not likely to have some legs, just based upon your experience, maybe having as a judge, as a practitioner, as a lawyer, as a professional? What do you see in it?
That's a question that's going to require 45 minutes to answer. We don't have 45 minutes, but just take it from the top. You said it's likely radical. I would say it's extremely radical, but I think it's absolutely the right thing to do. Keep in mind that the 1978 code took 10 years in a less contentious time. I mean, the original Bankruptcy Commission started in 1968, and we didn't have the code until 1978. in more contention times, the Bankruptcy Reform Act of 2005 itself took 11 years from the start of the commission in 1994. So I mean, I think this is the start. It's not the end by any stretch of the imagination of it, but it's a good start because we do need to rethink how consumer insolvency and consumer inability to pay should be handled, because we're in a different world now than we were in 1978, especially with respect to consumers. The car loans, house loans, those types of things have been the forefront of bankruptcy. And bankruptcy right now is a middle class phenomenon. It's not really for poor people. They don't need it. I mean, they don't have any assets, and no one can go after them. This provision does what other countries, in particular England and Ireland, have done, is said, listen, if you're a Nina, no income, no assets, you go through lickety split, you get a discharge, and you can go on with a fresh start in that respect. So I think there's a lot of good ideas that all click together in the bill, but I think it's going to be a long time before anything gets adopted, just because of it's a comprehensive change, and that even in the best of times, that will take some time to work through the system. And these are contentious times. The Democrats say something is pink, and the Republicans say, no, it's blue. I mean, they'll argue about anything. And when we get down to bankruptcy issues, sometimes that hits some key constituencies. Now you ask what might get parts of this might come through. My personal opinion is it's a lot of what will happen will turn on the reception and the success of the changes that just recently were made with respect to Chapter 13 debt limits. If in fact, that's a pretty radical change to go from, we're going to count unsecured and secured debts differently, to just kind of a package deal with a different limit. If that works, and by works, I mean works both for debtors and for creditors, then I think you'll see more receptivity to kind of more organic changes to the code. Now, and also I'll throw in subchapter V. Subchapter V is by most accounts a fairly rousing success. Success breeds success. If people see that, oh, well, yeah, the thing was creaky and changes did make a difference, we have more receptivity because more people think it's in their interest to change this. Now, things that I think will be difficult, the creditor lobby, and particularly the secured creditor lobby, doesn't like things to change. They want all the assets. They want all the marbles. And we'll go to great lengths to get them. Every time we've gotten to a position where, for example, we're mark-to-market mortgage loans, the finance industry has basically said that's an apocalypse. The world as we know it will end. I think they're wrong. Although I am told that at the height of the 2008 recession, if you mark-to-market all home loans, then both Citibank and Bank of America would have been insolvent. But put that aside, it just makes a lot of sense to get rid of this notion that bankruptcy judges can't value homes to give relief to parties. It's just kind of ridiculous that people can do that for some collateral, but not others. And hats off to the bill on that point. But moving off of that dime for much of the financial industry will take a lot of log rolling, old-fashioned log rolling, and I have no idea what's going to be given up to get that.
Yeah, I think so.
I'm dealing with the bank lobby. I know it's tough from a lot of things that I've experienced over the years, just as a bankruptcy trustee, and I know that they can dig their feet in pretty deeply. Save your point for a second, Professor Laws, I want you to have it, but I wanted to raise the question that came from the audience here, and the question was, under the proposed legislation, would the debtor be able to re-amortize mortgage secured by residents? So yes. Maybe Bob, you want to take that one because you know the statute. I think the answer is yes.
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 Okay. Next point, Bob.
I was just talking about I wanted to talk a little bit about the political dynamic, right? So The first point, and I know Bruce will agree with this, never underestimate Senator Warren.
Right.
I think she put out the idea for the CFPB when she was a Harvard law professor, right? Not even in government. And now, and a lot at the time, a lot of people thought it was a pipe dream, and we have a CFPB.
If you're in the Fifth Circuit, it is now too, but
Yeah,
that's
that's
another
right.
matter.
Well, we'll see. That's something else we can talk about. But but also, the political moment. We're all imagining right now the same political moment we have right now. Political moments change, right? You could imagine, and to go back to the Great Recession with Dodd-Frank, right, and all the consumer finance reforms, which part of which was the Consumer Financial Protection Bureau, but not just that, right? There's all sorts of things in the Truth in Lending Act and changes to the mortgage markets. To your point about secured creditors, right? The whole qualified mortgage thing, I think, would have been impossible to imagine happening just a few years earlier. So, political moments change when legislation is on the shelf, and political moment changes. Sometimes that legislation gets taken down and advanced through Congress. So, would I, if I could bet on this bill getting passed, would I bet on that? No, but I wouldn't say. I think many people are too quick to dismiss the idea that this is never going to happen. Again, political moments change.
Things change. I mean, I don't think that people really appreciated how much the bankruptcy code would change back and when the code was first enacted, and I don't think people in that expected how much the code would change when BAP-CEPA passed. But every 40 or 50 years, things change. Well, it's been now almost 15, 20 years since the last round of code changing, and the world's changed. So I think the code will change as the world changes too. How it will come out, we don't know. One of the things that you spoke about earlier, and I think bears a little bit further discussion, is the current status and future of the CFPB, particularly in light of Community Financial Services Association versus CFPB. So maybe you'd like to tell everyone about that and what that, I'll use the word augurs again, or whether it's just something that's all just screwed up.
Okay.
Points for that. Yeah.
Too much wordplay. So as probably most everyone knows, right? So the Fifth Circuit, just kind of out of the blue, in a case challenging the CFPB's payday lending rules. So maybe I can even back up a little bit and talk about that. And this is a consumer bankruptcy session, but as we all know, we need to pay attention to these adjacent areas of law, and the CFPB is in a lot of these adjacent areas of laws, and one of them was their payday lending rule. So the payday lending rule came out. It had an underwriting component that the Trump administration, when they took over, withdrew. But what they left in place was the part of the CFPB rule, a payday rule, that prohibited or limited the number of times that a payday lender could make an ACH demand on a customer's account, which has the effect, when payday lenders do that, that has the effect often of running up overdraft fees. And so the idea that the regulation was, we're going to limit the amount of times that a payday lender can hurt a consumer by
unilaterally hitting their account and drawing money.
Exactly. So even that was right. Was very little, because for the rules of the National Automated Associated Clearinghouse, or whatever, the NACA, the oversight clearinghouse organization, already pretty much prohibit what the CFPB rule would do. But even that was too much for the payday lending industry. So they challenged the payday lending rule and were, memory serves, successful in the lower court. It gets up to the Fifth Circuit, and the Fifth Circuit decides the payday lending rule is valid as enacted. And at the very end of the opinion says, oh, but by the way, the CFPB is unconstitutional.
Not just unconstitutional, but because it's unconstitutional, ...
Yeah.
Everything they do is invalid.
Yeah, well,
everything they do.
Technically, they said the payday lending rule is invalid because it was passed. So the ground for unconstitutionality is that the CFPB source of funding violates the appropriations clause.
Right.
And now I realize we're talking about the Constitution again. But the appropriation clause requires all money spent by the federal government to be appropriated. The CFPB's funding comes from by levying a assessment on the Federal Reserve System. And note, by the way, that doesn't actually violate the appropriations clause because it's not.
Well, I mean,
within the
what it
meaning
is, the CFPB is housed in the same reporting line, if you will, as the Federal Reserve. The Federal Reserve doesn't get tax money. It gets money from insurance fees from the FDIC. They get, they charge their users, and that's their budget. And then the money from that comes out of, well, that money then is used by request from this or demand from the CFPB, and that gets passed down that way. So the things that they were doing was from money that was not appropriated by Congress. And so the Fifth Circuit said, you can't have anybody with executive or legislative powers making rules where in fact the expenditures for that were not subject to appropriation. And again, this is, I mean, how many words, Bob, was this in the appellate's argument?
Well, but I just want to make sure.
Yeah.
So I was making a little bit different point.
Okay.
So the text of the appropriation clause says if you spend money, I'm paraphrasing, but basically, if you spend money from the Treasury, it has to be appropriated.
Right.
The text of the appropriations clause itself does not say all federal operations have to be done through appropriated funds, although that's the upshot of the Fifth Circuit opinion.
Right. Well, the other thing just to point out is the Fifth Circuit opinion, it's not completely out of the blue, because the Fifth Circuit through Edith Jones had another opinion,
Fair
which they basically glommed onto and said, this is great stuff. I mean, the Supreme Court at some point is going to have to resolve this, because as one of the questions that just popped into the chat indicate, there are a lot of other agencies, bureaus, you pick the synonym, that are not necessarily funded in the way in which the Fifth Circuit thought everything should be funded. And so, yeah, the Federal Reserve might have a problem, which might have been an issue back in 1824, but I don't think it's been an issue since then.
Yeah, and I agree with all of that. So now the poll's covering my face, which I think is a feature, not a bug.
I agree.
Yeah, so fair enough. But so absolutely, right? So the question asked, wouldn't this reasoning threaten the Federal Reserve itself? And I think that's right. The Fifth Circuit tries to make this argument that the CFPB's funding is somehow double insulated because since it flows through an agency that itself doesn't go through the appropriations process. There's this evil of double insulation. Seems like a very extra constitutional.
Right. I mean,
idea.
basically, it's appropriation clause and separation of powers. I mean, it's.
But wait, you're trying to make the opinion. You're trying to make the opinion be something that is other than what it says. It's the opinion talks about double insulation.
Right.
Your position is more reasoned than what's in that opinion.
Well, yeah, I'm trying to make it better than it is.
Well, I think that opinion basically came up with the answer and then tried to justify how it got to the answer. It was itching for a fight, and it basically found a little hook with which it could, scratch its itch, right?
Yeah, it's Jay Westbrook's metaphor that they shot an arrow into the air, and then when it hit the ground, they painted red concentric circles around where it hit, to say that they hit the target. Yeah. I mean, it's and it's going to have to get resolved because the CFPB has so many rules that are affecting the financial industry that everybody's got an interest in having this resolved and quickly, I would think.
Yeah, I think
you raise the point, because if the CFPB does go, then this opinion has collateral consequences, which are just frightening to think about, aren't they?
Yeah, I mean, I think so. I just want to go back to something on this being out of the blue. I think so I would tell everyone to read the opinion. It's kind of oddly crafted in my mind because, again, they go through all the statutory stuff, and then it really does read like, oh, by the way, this is unconstitutional.
Yeah, I mean, 7/8 of the opinion is, everything the CFPB did was great. It says, they rejected all the direct attacks on the payday lending
It's
rule.
statutorily authorized with the CFPB.
They just get down to the end and they say, oh, by the way, everything we just did
And
is
there were
not necessary, basically.
there were 300, like, it's just something like 360 words devoted in the appellant's brief to the constitutionality of the CFPB. A responsible court, as you people might tell, I'm pretty angry about this. I think this was incredibly irresponsible. And the responsible court might have asked for supplemental briefing on that issue. Right, they did not. So the credit slips blog I administer, Adam Levitin, has a post up there about how the Fifth Circuit even got its facts wrong about the exact funding mechanism for the CFPB and how it's actually runs through the Federal Reserve System, which is different than the Federal Reserve itself, and those are private banks, and thus it is pretty much like the OCC and the FDIC, which makes assessments on private entities.
Can I just take a minute there as a footnote? You mentioned Adam Levitin and credit slips. Credit slips is an excellent source for these kinds of things. And one thing we didn't mention when we talked about student loans is that Pam Fooey, now at Cardozo, has already posted an analysis of the student loan documents posted by the DOJ. And if you want more, that's a good place to read about it as well. Yeah,
thank you. We did forget to mention that. It was posted about a half an hour before the session started. So everything on that and the student loan thing is brand new.
So gentlemen, we are running a little bit short of time, but before we do, let's change pace and look at something completely different. And that's what you think will happen to Rule 7001 in light of the Fulton case. And that's a little different, but I think of equal interest, or at least important interest to many of the people listening here.
So both Bruce and I signed a professor's letter proposing changes to Rule 7001 in light of the City of Fulton, which I will say I think the Supreme Court unfortunately got right. I say unfortunate because I wish the law were different, but I think the law.
I disagree, but that's moot at this point.
Yeah, it is. Well, the Supreme Court agrees with one of us.
And I don't know if that's a feature or a bug.
Yeah, okay, fair enough. But I do think, I think the result was bad policy, and part of it is that you have to bring a adversary proceeding for a turnover. So the letter that there were like 70 law professors. No, yes, it was like 70 law professors signed the letter proposing some fairly big changes to the turnover process, not just for automobiles, but generally. It was well reasoned. The proposal, supported. There were a lot of different ideas going on in the proposal. What the Rules Committee came back with was a much more narrow change, which is that it will no longer be required to have an adversary proceeding for a turnover of a tangible personal property in an individual debtor's case.
So cars.
As I say, it's a long way of saying cars. Yeah. So that's what
I'm saying. When does that rule go into effect?
So I think if I did the arithmetic right, the earliest it will come into effect is December 1st, 2024. So for those who aren't aware, the rulemaking process to change the federal rules of bankruptcy procedure, or any of the federal court rules, is long and drawn out. And so
3 years at a minimum, usually.
Yeah, the rule's up for public comment right now. So anybody that thinks this is a good idea and supports it could leave a public comment.
Or wants to expand it.
And I'll tell you what, public comments are important because those comments are read, they're considered. I've talked with many people who serve on the committee that listens to these public comments. So this is an important feature. Before we go, you also mentioned earlier the impact of the increase in thresholds. Now we know that the thresholds increase in two important ways. First of all, the universal increase of threshold for Chapter 13, and secondly, the semi-permanent increase in thresholds for Subchapter 5. I can tell you that the increase in thresholds for Subchapter 5 has made a big difference. I can tell you that there's lots and lots of cases that are being filed under Subchapter 5 that are having profound effects. Cases that would have failed, that would have been liquidations or assignments previously, are now successful reorganizations under Subchapter 5. But tell us what you think is going to happen in terms of the Chapter 13 world, because I don't think that that's been followed that closely, and I haven't seen the impact of it in practice quite so much yet.
Bob, your turn.
Okay, well, I know I was going to leave it to you because I think we might have a difference of opinion. I'm not as sure that that's going to be as big a game changer. So the new threshold, if you're for those that aren't aware, is $2,750,000 for Chapter 13.
No,
The distinction,
2,750, you said 1,000.
what did I say? 2,750,000. Yeah, 2,750,000. If I misspoke, I apologize. But the amendment changes where it used to have a separate threshold for unsecured and secured debt. Now it's $2,750,000 all in, all total debt, unliquidated or liquidated and non-contingent debt. Yes, right. There are certainly cases that bump up against that threshold and end up in, Chapter 11 or subchapter 5, or just end up not being able to file because of the cost of those proceedings. But those are not a large number of the cases.
Well, I mean, my concern, and again, this is born from experience in Nevada,
Yeah.
in areas like California and other places where housing prices are insane. The old secured limit pushed a fair number, and Bob might have the exact number, but I think it's a fair number of people into Chapter 11. That did a couple of things. One, Chapter 11 just does not work for a consumer. In most cases, it's too complicated, it's too expensive. Two, with all apologies to the lawyers looking out here, Chapter 13 lawyers aren't Chapter 11 lawyers. It's a different skill set. And I saw a lot of homeowners who were in Chapter 11 because of that debt limit getting ill-served by lawyers who, in good faith, were trying to comply with Chapter 11, but just didn't have the training or the skill set. And I think this solves that problem in those areas, basically metropolitan areas, basically areas where housing prices have skyrocketed. But beyond that, I think you're right, Bob. I mean, the major aspect of most consumers' debt would be housing, and to the extent that this affects housing, I think it's a good thing that it keeps more into 13. The other thing is it may bring into, and I have no idea now, in some smaller cases with sole proprietors, might give them a choice between Chapter 13 and subchapter V. And I think choice is a good thing, and I think the lawyers who are doing subchapter V actually ought to consider that, because a 13 might be a better choice in some cases. Neither have the absolute priority rule, so you have that going for you.
So before we go, we have 5 minutes left, guys. I would like you to tell us quickly one thing that you would like to see happen in the bankruptcy code. If there's just the one thing you could change tomorrow, what would it be?
Make student loans freely dischargeable after 5 years and with undue hardship before that.
And if you don't do that, allow mortgages to be marked to market, regardless of origin.
I agree with that, but that's not the second most important thing. The second most important thing, and I think it actually competes with the first most important, is allow attorney's fees to be paid over time in a Chapter 7 post petition.
Three
That would be a
things.
game
And then
changer.
one pet peeve: we should get rid of credit counseling and financial management courses because they don't accomplish much.
So yeah, right. But you asked for the one thing, right? So
No,
absolutely,
I'm
we should
agreeing
get
with
rid of
you,
those.
but I'm just saying lightning round, right?
Okay, so yes, we should get rid of those. I think the attorney thing, I think that affects so many things about, everything from chapter choice to, whether somebody can file at all, right? And when they file. I think another thing, the trustee fee, right? So we're supposed to get a higher
absolutely.
trustee fee.
Absolutely. I mean, although trustees can be a pain in the butt, they do, without them, the system doesn't work.
What would be the role of the trustee under Chapter 10? I'm just wondering what a Chapter 10 trustee would be doing exactly.
Well, they would be doing a lot what Chapter 7 trustees do now. Plus, they would have, when people didn't pay their plans, they have a collection rights on the unpaid amount and recovery of their costs and fees for that. So I think that's one of the, I've heard criticisms, well, this does away with trustees. It doesn't at all. And actually, in many ways, there's even in many cases, more work in a lot of these, would it be in a lot of these chapter 10s. But, you know, just like now, right, where there's a small number of cases that generate most of the income for chapter 7 trustees, I think that would also be true into the new chapter 10.
Yeah, I
What
think
would happen-
also,
What would happen to the chapter 13 standing trustees now? Would they disappear?
Well, there's no chapter 13.
So they would disappear.
The bill leaves it up to the U.S. Trustee's office to whether there, you know, would be panel trustees, or you could imagine there being standing chapter 10 trustees, but that would be.
I mean, one of the things that you have to, I mean, my kind of last shot on this is, I think one of the reasons that subchapter V has been a success is that it was modeled on chapter 12 and chapter 13, and the trustees are giving some neutral advice to people about how to reserve things. In essence, it's cutting down the emotion and increasing the rationality. You might see, you might see the retention of trustees, at least with respect to those who want to do a payment plan, to try and figure out whether they're right-sized in housing or what have you.
Yeah, and I see in the chat, somebody mentions collection agencies. I should also make clear that to the extent that somebody was paying through a plan, that the chapter 10 trustee would operate much like a chapter 13 trustee now and collect a percentage of that. It's only when the plan fails that then they would also have collection rights.
Well, I'll tell you, gentlemen, it's been a very, very interesting and lively presentation. I've appreciated the fact that you've jumped in. I've appreciated particularly the flexibility you showed to be able to adjust to the very rapidly changing scenarios that we've had in bankruptcy. I mean, 24 hours is not bad response time. So I just would like on behalf of the ABI and on behalf of everybody, thank you very, very much for your participation today. Excuse me, I don't know why, but I've got a cold. So let's wrap up this presentation by saying I'd like to thank you for joining us today. This is the last day, but all of the sessions are going to be recorded and they'll be available on demand at least until December 12th. Maybe if we ask nicely, it'll be available a lot longer than that. I'd like to thank the panelists. I'd like to thank the audience for its participation. Please take a moment to look in the chat box to complete the session evaluation. Very important to get your feedback and you need to complete it if you want to get CLE credit. So please take it. And again, the link for CLE, the link for the evaluation is in the chat box. So thank you everyone very much. We wish you a pleasant good day and a good weekend and all the best for the holiday season as well. Thank you, gentlemen. Good day.
Thank you all.
Thank you.